All right, so buckle up, everyone. Today, we're diving deep into a topic that's, let's face it, pretty crucial for a lot of folks out there. The Spanish urban leases law, that whole legal framework surrounding renting in Spain.
The LAU, as it's commonly known.
Exactly, the LAU. And think of this deep dive as your shortcut to really getting the ins and outs of how renting works here, whether you're on the tenant side or the landlord side.
We're going to break down this whole legal framework piece by piece. We'll look at all the different aspects that really matter to both sides of a rental agreement.
Because it can be a bit of a maze, to be honest.
Oh, it definitely can. It's a pretty comprehensive piece of legislation. And honestly, understanding its key components can save you a whole lot of potential headaches down the line.
Absolutely. And we're not just talking about renting a typical apartment here. The LAU actually covers a whole range of urban leases.
Everything from, residential housing to those commercial spaces.
Professional offices, you name it, it's all in there.
And what gets really interesting here is that the specific rules that apply can actually depend quite a bit on when that lease agreement was actually signed. We're not just talking about the current law here.
Right. We've got to keep in mind that there were different legal regimes in place before the main law that's in effect now, which is Law 29994, as amended over time.
We're talking about contracts signed before May 9th, 1985. Then there's those signed between May 9th, 1985 and December 31st, 1994, and then everything that was signed from January 1st, 1995 onwards.
So basically, three distinct periods with their own sets of rules.
The current law, with its amendments, is our main focus here, but those older contracts still operate under their own specific rules.
Right, so let's not forget about those. But to really kick things off, let's dig into those different types of urban lease agreements that the LAU actually covers, as defined in Articles 2 and 3.
Sounds good to me.
All right, so let's break it down. First up, we've got what's called an arrendamiento de vivienda. So basically a housing lease. This is essentially when a habitable building is being rented out, and its main purpose is to be the tenant's permanent residence.
Their home.
Their home, right. But it's not just about the four walls, is it?
No, the regulations actually extend to things like furniture that might come with the property, any storage rooms, parking spaces, and basically any other annexed spaces or services that are being provided by the landlord.
Okay, so it can get pretty detailed.
It can, but here's an important thing to note. Short-term seasonal rentals, those that last less than a year, are specifically excluded from being considered housing leases under the LAU.
So think of it like your summer vacation rental. Those rules don't really apply here in the same way.
Right.
Okay, so your summer beach house rental wouldn't be subject to these specific housing lease rules. Then we've got the other category, arrendamiento urbano para uso distinto del de vivienda. That sounds kind of like a catch-all term, to be honest.
It is, in a way. This basically covers any lease of a building where the main purpose is something other than housing. This includes those seasonal rentals that we just mentioned,
Like the vacation ones.
as well as properties that are being rented out for industrial, commercial, professional, recreational, welfare, cultural, or educational activities. So a shop, an office, even a yoga studio would fall under this category.
So like that hip new cafe that just opened up down the street.
Exactly.
That would be in this other uses category. But I do remember reading something about industrial activities having their own separate set of rules.
That's a crucial distinction to make. Leases that are specifically meant for industrial activities, like that functioning cafe you mentioned, are actually governed by the Civil Code.
Not directly by the LAU's provisions for other uses.
Right.
Gotcha. So two big buckets under the LAU, housing and other uses, with that civil code exception for the industrial stuff. Now, what about those core principles that really underpin this whole legal framework? What are the ground rules here?
Articles 4 and 6 of the LAU set out some key principles. And one of the most important ones is that Titles 1, which defines the scope of the law, and Title 4, which has those common provisions like stuff about the security deposit, these are mandatory for all leases regulated by the LAU.
So no getting around those.
Whether they're for housing or for other uses.
No getting around those. What about the stuff that's more specific to housing leases in Title 2?
For housing leases, the agreement between the landlord and tenant really takes center stage. The law says that these agreements will prevail, but they have to respect the overall framework laid out in Title 2. And this is really important for tenants. Any clause in the contract that's actually detrimental to the tenant or a subtenant that's considered null and void unless the law specifically allows it. This is a clear attempt to protect the more vulnerable party in a housing lease.
Makes sense, right? It stops landlords from sneaking in unfair clauses.
Exactly.
Think of things like clauses that would force them to pay for repairs that are really the landlord's responsibility.
Those generally wouldn't fly.
Okay, good to know. What about those other leases we talked about? Do they have the same level of protection for the tenant?
Not quite. For leases for other uses, as well as for those really large housing leases, the ones over 300 square meters or with rent exceeding 5.5 times the annual minimum wage, the principle of autonomy of will, so what the parties agree to, that holds even more weight. The will of the parties, as expressed in the contract, that takes precedence. After that, Title III for other uses and then Title II for housing, they apply. And finally, the Civil Code steps in as the backup source of law, so there's a lot more flexibility in those kinds of agreements.
Okay, that's a clear distinction. Now, a big concern for anyone renting is always the duration of the agreement. How long does it actually last? What does the LAU say about how long those housing leases run for?
Articles 9 through 16 cover this in detail. The initial term of a housing lease is freely agreed upon by both parties. However, if that initial term is less than 5 years, or 7 years if the landlord is a legal entity like a company, the contract is automatically extended on a yearly basis until it reaches that minimum duration. This provision actually offers considerable security to tenants, preventing landlords from abruptly terminating contracts and forcing frequent moves, which can be disruptive and costly.
Automatically extended, so a tenant who signs a one-year contract could potentially stay for 5 years even if the landlord doesn't want them to.
Unless the tenant gives notice that they don't want to renew.
Right.
They need to give at least 30 days notice before the end of that initial term or any of the yearly extensions.
Good to know for tenants. What if there's no term stipulated in the contract or just says indefinite?
In those cases, the law presumes that the term is for 1 year.
Yeah.
But the tenant still retains that right to those annual extensions up to the 5 or 7 year minimum.
Okay, so quite a bit of security there for the tenant. But what about the landlord? Can they get their property back before that minimum term is up?
Yes, there's a specific exception. After the first year of the lease, the landlord can actually prevent that mandatory extension if the contract expressly states their need to recover the property as their permanent residence. This could be for themselves or for a first-degree relative, or even in cases of legal separation, divorce, or annulment of marriage.
There are strings attached, though, right? They can't just say it and kick the tenant out.
Definitely not. The landlord has to give the tenant at least 2 months' notice of this intention. And here's where it gets really interesting for tenants. If the landlord or their declared beneficiary doesn't actually occupy the property within 3 months of the tenant leaving, the tenant actually has options. They can choose to be reinstated in the property under the original terms of the contract for a new period of up to 5 years, with compensation for moving and relocation expenses. Or they can choose to receive financial compensation equivalent to 1 month's rent for each year that remained until reaching those 5 years, unless the lack of occupation was due to unforeseen circumstances beyond the landlord's control. That's pretty solid protection for the tenant right there.
Wow, that is significant protection for the tenant. What happens once those initial 5 or 7 years are up?
If neither party gives notice of their desire to terminate the contract, the landlord needs to give 4 months' notice, and the tenant, too. Then the contract is tacitly extended on a yearly basis for a maximum of 3 more years. During this tacit extension, the tenant can still give 1 month's notice before the end of each annual renewal if they want to leave. It's like the contract just keeps rolling over automatically unless someone says stop.
What if the tenant wants to leave before that initial 5 or 7 year period is up? We touched on that briefly with the landlord's need to recover the property. But what if the tenant just has a change of plans?
Article 11 covers the tenant's right to withdraw from the contract, known as desistimiento. After the first 6 months of the lease, the tenant can actually terminate the contract by giving the landlord at least 30 days' notice. However, the contract might include a clause that requires the tenant to compensate the landlord. This compensation is usually 1 month's rent for each year of the contract that's still left to run. If the remaining period is less than a year, it's calculated proportionally.
So there might be a financial penalty for leaving early, unless the contract doesn't say anything about it. All right, let's move on to another area that can get a bit complex. Subrogation. What happens to a housing lease if the original tenant's circumstances change? Things like marriage, divorce, even death.
Subrogation. It's like passing the baton in a legal race. One person essentially steps into the shoes, legally speaking, of another.
Exactly.
Articles 12, 15, and 16 deal with these scenarios. Let's start with subrogation. due to the tenant withdrawing or the contract expiring upon marriage or starting to live with a partner. In these cases, if the tenant decides not to renew or wants to move out, the landlord can actually ask the spouse or partner if they wish to continue with the lease. The spouse or partner has 15 days to declare their intention. If the tenant just abandons the property without saying anything, the spouse or partner has a slightly longer period, 1 month, to notify the landlord if they want to take over the contract.
Makes sense, right? It prevents someone from suddenly being homeless if their partner leaves. What about legal separation, divorce, or annulment of marriage?
In those situations, if a judge awards the non-tenant spouse the right to use the dwelling, that spouse can actually step into the shoes of the original tenant and continue the lease. They need to notify the landlord of the court decision within 2 months.
And then there's the tough situation of the tenant's death. What happens to the lease then?
Article 16 sets out a specific order of who can subrogate in case of the tenant's death. This includes the spouse, the de facto partner, direct descendants like children and grandchildren, ascendants like parents and grandparents, siblings and other relatives who had a disability of 65% or more.
Yeah.
But these individuals must have been living with the tenant for at least 2 years before their death.
So it's not just anyone, there's a cohabitation requirement.
Exactly. They need to notify the landlord of their decision to subrogate within 3 months of the tenant's death, and they'll need to provide documentation proving their relationship and cohabitation. However, there's a potential exception to this right. In leases that are longer than 3 years, the landlord and tenant can actually agree to waive this right of subrogation in case of death. But this waiver isn't allowed if any of the potential subrogating parties is in a situation of special vulnerability, like being a minor, having a disability, or being over 65 years old. This is another key protection for vulnerable individuals.
The subrogation rules seem designed to provide some stability for those who are living with the tenant. Now, what if the landlord's own legal situation changes? Like if the property gets sold, or if the landlord's ownership rights are terminated in some way? This is legally called resolución del derecho del arrendador, and it's distinct from a sale.
Like if the property reverts back to someone else for a legal reason other than the landlord deciding to sell it. Articles 13 and 14 address these scenarios. If the landlord's right over the property is terminated for whatever reason, the tenant has the right to stay in the property until that minimum 5 or 7-year term of the lease is fulfilled. The big exception here is if the lease agreement was registered in the property registry before the event that caused the landlord's rights to be terminated. In that case, the lease will actually continue for the entire term that was originally agreed upon. So registration actually offers even greater security to the tenant.
So registration offers even greater security for the tenant. What about a straight-up sale of the property? What we call enajenación de la vivienda arrendada.
In that case, Article 14 states that the new owner is subrogated into all the rights and obligations of the original landlord for at least the first 5 or 7 years of the lease agreement, respecting that minimum duration we talked about earlier. This again provides significant protection to the tenant, ensuring their lease continues even with a new owner.
That's good news for tenants. A change in ownership shouldn't automatically mean they have to move out. Okay, let's talk about the aspect that probably worries everyone the most: rent. How is rent determined, and can it be increased under the LAU?
Articles 17 to 20 cover everything related to rent. Generally, the initial rent is freely agreed upon between the landlord and tenant. However, there's a big exception in areas that have been officially declared as stressed residential market areas. You know, those with rent control measures in place. In those areas, there are actually limitations on how much a landlord can charge for a new lease.
Right, rent control is a whole other topic. What about the mechanics of paying rent?
The law specifies that rent payments must be made monthly, within the first 7 days of the month. And the landlord can't demand more than 1 month's rent in advance. The preferred method of payment is electronically. But if one of the parties doesn't have a bank account or access to electronic means, payment can be made in cash at the property. Importantly, the landlord is obliged to provide a receipt for the payment, unless it was made via a verifiable electronic method.
And there's even a provision about potentially exchanging rent payment for renovations. That sounds interesting.
Yeah, Article 17 actually contemplates the possibility of the tenant agreeing to carry out renovations on the property instead of, or as part of, their rent payments. This has to be a specific agreement between both parties, of course.
Interesting. What about rent updates during the term of the lease? Can the landlord just raise the rent whenever they feel like it?
No, rent updates are usually annual and have to be done according to what was specifically agreed upon in the lease contract. If the contract doesn't mention a specific index for rent updates, then the Competitiveness Guarantee Index applies by default. But with a cap at the Consumer Price Index, the CPI, the landlord must notify the tenant in writing of any rent increases, including the applied percentage, and if requested by the tenant, actually provide certification from the National Statistics Institute, the INE, confirming the variation of the index.
What if the landlord makes improvements to the property? Can they increase the rent then?
Yes, but only after that initial 5 or 7 year period of the lease has passed, unless there was a different agreement. The landlord can increase rent for improvements made to the property, and these have to be improvements, not just necessary repairs to maintain habitability. But the increase can't exceed 20% of the current rent. The calculation of this increase is based on the capital invested in those improvements, plus the legal interest rate of money, plus 3 percentage points. The landlord also needs to notify the tenant in writing about the increase and provide details of how it was calculated. Think of it like the landlord can recoup their investment plus a little extra, but there's that 20% cap to protect you from outrageous increases.
And who's responsible for those general building expenses and costs for individual services like water or electricity?
The LAU allows the landlord and tenant to agree in writing that the tenant will bear the general building expenses, things like community fees. However, this agreement needs to be in writing, and it needs to specify the annual amount of those expenses. Costs related to property management and formalizing the lease agreement are the landlord's responsibility, especially if the landlord is a legal entity. And the costs for services that are individually metered, like water, electricity, or gas, those are always the tenant's responsibility.
Okay, that clears up a lot about the financial side of renting. Now let's shift gears and talk about the rights and obligations of both parties during the lease. What are some of the key responsibilities that each one has?
Articles 21 to 25 outline these aspects. One fundamental obligation of the landlord is to carry out all necessary repairs to maintain the property in habitable conditions, and they can't increase the rent for doing so. The exception is if the damage is the tenant's fault, of course. The tenant, in turn, has the obligation to inform the landlord as soon as possible about any repairs that are needed. So the landlord has to keep the place livable.
The landlord has to keep the place livable. What if those repairs take a long time?
If the necessary repairs last more than 20 days, the tenant has the right to a proportional reduction in rent based on the part of the property they couldn't use during that time. It's also worth noting that small repairs, due to ordinary wear and tear, those are the tenant's responsibility.
Fair enough. What if the landlord wants to carry out more major improvement works, not just basic repairs?
The landlord has to notify the tenant in writing at least 3 months in advance of any planned improvement works, detailing their nature, start date, duration, and estimated cost. Upon receiving this notification, the tenant actually has a choice. They can terminate the contract within 1 month, or they can stay and demand a reduction in rent proportional to the part of the property they can't use during the works. That seems fair.
That seems fair. What if the tenant wants to make changes to the property?
Generally, the tenant needs written consent from the landlord for any works that alter the configuration of the property. There's an exception for tenants with disabilities who only need to notify the landlord in writing about any adaptations needed.
No prior consent required.
However, even in those cases, the landlord can demand that the property be returned to its original state when the lease ends.
And finally, on the right side, what if the landlord decides to sell the property during the lease? Does the tenant have any say in that?
Yes. Article 25 grants the tenant preferential acquisition rights, known as tanteo and retracto. This means that if the landlord intends to sell the property, they first have to offer it to the tenant under the same conditions they would offer it to a third party. The tenant has 30 days to exercise their right of tanteo. If the landlord sells the property to someone else without offering it to the tenant first or under less favorable conditions, the tenant then has the right of retracto, which means they can legally step into the buyer's shoes. But they have to do so within 30 days of being notified of the sale. However, the tenant can waive these preferential rights by a specific agreement in the lease contract. If they do that, the landlord still needs to notify the tenant of their intention to sell at least 30 days before the sale is formalized. These are important rights that tenants should be aware of.
Important rights the tenant should be aware of. Let's move on to how a lease can be suspended, terminated early, or naturally come to an end. What does the LAU say about those situations?
Articles 26 to 28 cover these aspects. Suspension can happen if the landlord carries out works that make the dwelling uninhabitable. In this case, the tenant can choose to suspend the contract, which means the lease term and rent payments are paused until those works are done, or they can terminate the contract altogether without having to pay any compensation to the landlord.
What about early termination or resolution? What are the grounds for that?
Article 27 lists the reasons why either party can terminate the contract before the agreed term. The landlord can terminate if the tenant doesn't pay rent or the deposit, sublets, or assigns the property without permission, intentionally damages the property, or carries out unauthorized works, engages in nuisance activities, or if the property ceases to be the tenant's permanent residence. On the other hand, the tenant can terminate if the landlord fails to make necessary repairs or if the landlord disturbs the tenant's use of the property.
And what about the natural termination of a lease?
Article 28 states that a lease can be extinguished by the loss of the property for reasons not attributable to the landlord, like a natural disaster, or if the property is officially declared in a state of ruin.
So those are the rules mainly for housing leases. What are some of the key differences when we look at leases for other uses, like commercial spaces?
Articles 29 to 35 deal with these. One significant difference is regarding the sale of the property. In a lease for other uses, the lease will actually continue with the new owner.
They're subrogated.
Exactly. The rules regarding conservation, improvement works, and the tenant's right of preferential acquisition, those are generally the same as for housing leases, referring back to the relevant articles in Title II.
But I do remember reading something about more flexibility for subletting or signing commercial leases.
That's a key distinction in Article 32. If a business or professional activity is being carried out on the premises, the tenant can actually sublet the property or assign the lease agreement without needing the landlord's consent. However, the landlord has the right to increase rent in those cases, 10% for a partial sublet and 20% for a total sublet or assignment. The tenant is still obliged to notify the landlord of the sublet or assignment within 1 month.
What about subrogation due to the tenant's death in a commercial lease? Same rules as for housing.
Article 34 allows subrogation due to the tenant's death in favor of an heir or legatee who continues that business or professional activity that was being carried out on the premises. They have to notify the landlord of their intention to subrogate within 2 months of the tenant's death.
And how can a lease for other uses be extinguished?
Like housing leases, they can be extinguished due to a breach of contract, destruction of the property, or expiry of the agreed term. However, there's a specific provision in Article 34 about compensation to the tenant if a commercial activity of public sale has been carried out on the premises for the last 5 years and the tenant offered to renew the lease for at least 5 more years at market rent. Under certain circumstances, the tenant might be entitled to compensation if the landlord doesn't agree to the renewal. Additionally, the landlord has grounds for immediate termination, similar to housing leases. These include non-payment of rent or the deposit, intentional damage, unauthorized works, nuisance activities, and unauthorized subletting or assignment without proper notification. So some similarities, but also some important differences, particularly around subletting and that potential compensation for commercial tenants.
Some similarities, but also some important differences, particularly around subletting and that potential compensation for commercial tenants. Now, Title IV of the LAU deals with common provisions. What are the key takeaways that apply to all urban leases under the law?
Articles 36 and 37 set out some fundamental rules that apply across the board. Article 36 deals with the security deposit, or fianza. For housing leases, this is equivalent to 1 month's rent, and for other uses, it's 2 months' rent. This deposit can be updated after those initial 5 or 7 years if the lease is extended. Importantly, if the deposit isn't returned to the tenant within 1 month of the contract ending and the keys being handed over, it starts accruing legal interest in favor of the tenant. The law also allows additional guarantees to be agreed upon, but for housing leases, these additional guarantees can't exceed the equivalent of 2 months' rent. Certain public administrations are exempt from having to provide a deposit, though.
So it's basically a safeguard that protects the landlord, but the law also makes sure that it's returned to you, the tenant, with interest if it's unduly withheld.
Right.
And what about formalizing that lease agreement in writing? Is that mandatory?
Article 37 states that either party, the landlord or the tenant, can compel the other to formalize the lease in writing. If this happens, the written contract needs to include the identity of the parties, a clear description of the leased property, the agreed duration of the lease, the initial rent, and any other clauses that were freely agreed upon.
Finally, we have to touch on those transitional provisions we mentioned at the beginning. Sounds like there are still some leases out there that aren't completely under the current LAU, especially those older ones.
Absolutely. Those transitional provisions, particularly the second one, address contracts that were signed before May 9, 1985, and those signed between May 9, 1985 and December 31, 1994. These older contracts are largely governed by the previous legislation, but the LAU introduced some specific changes, especially regarding subrogation rights and how rent can be updated. For example, those pre-1985 contracts have very specific and often more protective for tenants, rules about who can subrogate after the tenant's death and for how long. The contracts from the Decreto Boyer era between 1985 and 1994, those eliminated the forced extension of leases. It's a complex area, and anyone involved in a really old lease should really familiarize themselves with these transitional rules.
So as we've seen, the Spanish urban leases law is a pretty comprehensive piece of legislation with a lot of nuances. It's clear that the date your lease agreement was signed and whether it's for housing or other uses really impacts which rules apply.
Definitely. Understanding these regulations is absolutely vital for both landlords and tenants in Spain. It helps everyone know their rights and obligations, and it can prevent a lot of potential disputes down the road.
Absolutely. So for those of you listening out there, think about which aspects of the LAU we've discussed today might be most relevant to your own situation or areas of interest. If you're renting or planning to rent in Spain, or if you're a landlord, really digging into the specifics that apply to your situation is definitely recommended. And if things get complicated, seeking advice from a legal professional is always a good idea.
It raises an important question to leave you with. Considering all the intricate details and how the LEU has evolved over time, how effectively do you think these regulations actually balance the rights and responsibilities of both landlords and tenants in today's dynamic landscape of urban housing and commercial spaces in Spain? It's definitely something to ponder.